wife.
Objection, Your Honor. It is beyond the scope of both motions.
Our motion to dismiss talks about mens rea and the intent and the mind of the accused. And so I think if he's taking the risk of subjecting himself to a cross-examination from Mr. Duffy, well, then he can ask his questions as much as he wants on redirect.
What I can tell both parties with regard
case.
Did you speak with Anna Laura Hesbrook?
Objection, Your Honor, outside the scope of this hearing.
sustained,
I do not believe so, sir.
the objection's been sustained. That's okay.
Apologize.
You may continue, counsel.
Did you ever interview Mr. Allen regarding this incident?
No, sir, I did not.
Now, in your report, you said that there would be dead bodies everywhere. But did you see that that's a misquote to what's actually said in the recording?
That's what I heard in the recording.
So would you be surprised if the recording said something different?
Objection, Your Honor. That is. The state will withdraw that objection.
Okay. All right, you can answer the question if you can answer the question.
I listened to that audio recording several times, and to the best of my knowledge, to what I heard, that was correct.
That's all I have for him now, Your Honor.
All right, any further questions?
No further questions from the state, Your Honor.
All right, you may step down. If you'll just remove the microphone.
Thank you for reminding me, actually.
Any other witnesses from either side?
None from the state, Your Honor.
Defense?
None from defense.
All right, so what we'll do is we'll come back tomorrow and I'll hear arguments from both sides. And if both sides will be prepared to argue the motion to dismiss as well as the motion to suppress. And as stated, we'll take up the motion to suppress first. I'll make my ruling and then we can take up the motion to dismiss.
Thank you, Judge.
All right, thank you. Is there anything else?
Nothing further from the state, Your Honor.
All right, then defense, anything else?
I'd like to confer with Mr. Allen for a few moments, if that's okay.
All right, are you planning on calling him or no?
That's what I want to talk to him about.
All right, if you can state if you'll step outside to allow him to speak with him. And counsel, all right, defense, you may call your witness.
Yes, Judge, we're calling Ronald Lamar Allen.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. If you'll state your name for the record, please.
Ronald Allen.
All right, you may proceed.
Mr. Allen. Why did you say what you said in that recording?
Because I felt like the judges and the lawyers weren't taking this matter serious enough. I think that they were the reasons why my cousin committed suicide. And I believe that all the violence and all the murders that are with the family cases are because of they're toying around with it. And I think that there's dead bodies everywhere because of it. Every family situation, murder suicide I see on the news was related to a family dispute gone out of control. And that's what I was referring to.
And how many times have you been in the civil court?
236 times.
And that's how many temporary orders and settings that have been made?
Yes, sir.
236
Objection, Your
times.
Honor.
Yes, sir.
Leading, but also this is outside the scope of this hearing.
All right, that will be sustained.
Do you possess any firearms?
Nope.
Other than your ex-wife, has anybody else ever accused you of being violent?
Nope.
Objection, Your Honor, relevance.
Sustained.
What are your feelings towards Mr. Ireland now?
Objection, Your Honor, relevance.
All right, how is this relevant to the motion to suppress? And I understand the rules of evidence and that privilege. Communications of privilege, I understand how that relates to motions to suppress. And I understand that technically the rules of evidence do not apply to motions to suppress outside a certain number of rules. But with regards to this, how is this relevant to anything about the motion to suppress?
I think it's worth it for Mr. Allen to be able to say how he feels betrayed by his civil lawyer.
All right, that'll be sustained.
How many other civil lawyers have you had?
At least
Objection,
20
Your Honor.
something.
How is this relevant and this is outside the scope?
All right, that'll be sustained as to outside the scope of the hearing.
Well, Judge, I think that's kind of a hard item. I mean, we've acquiesced to let him testify in this suppression hearing because we think that he has an expectation of privacy regarding his communications with his own lawyer.
All
He
right.
should be able to talk about that, we believe.
Well, with regards to his expectation of privacy, because I'll note for the record, this hearing is a combination, I believe, of the motion to suppress and the motion to dismiss. So I will take this hearing as a combination of your motion to suppress and the motion to dismiss. Is there any objection from either side to the court hearing evidence for both of the motions at the same time?
No objection from the state.
I'm not opposed, Judge.
All right, if there's no objection from the state and the defense, then because you all are saying that you want the motion to suppress and then the motion to dismiss heard at the same time, then I will hear testimony from the witness with regards to your question of expectation of confidentiality.
And we think that's the efficient route.
Okay. All right, you may proceed.
Mr. Allen, you had so many different lawyers on your cases. Have any of them ever disclosed confidential information to the opposing counsel, to the representative for the child, or to the court generally?
The state is objecting to relevance outside of the scope. In support of that, we're talking about representation from other people. This is not relevant. And it does not go to what Your Honor has narrowly allowed expectation of confidentiality. This is outside the scope.
All right, so counsel, that objection does not pertain to your motion to dismiss or to the motion to suppress. So response
Well,
as to what other attorneys did.
I think it is relevant because it tends to, we're talking about an experienced person in relation to attorneys and what kind of expectations that he has regarding privacy and what is typically contracted in a civil attorney contract.
Right, well, you can question him about his expectation of privacy as it relates to Attorney Ireland.
Okay.
All right.
Did Ireland ever call you and ask you anything about your statements made in the office and the recording we heard?
No, he did not.
Did Ireland ever tell you that he was going to call the amicus attorney or call the police regarding what you said?
No, he,
Objection, Your Honor, relevance, but also an appropriate witness. We had Mr. Ireland on the stand and all these questions. There's a better witness for that.
He's a party to that conversation, Judge.
All right, I'll let him answer the question.
no,
Did Mr. Ireland ever ask you what you meant in that moment?
no,
Did Mr. Ireland ever express any fear or recoil? Did he act scared when you were in that meeting with him?
no,
What were the last things that Mr. Ireland told you at the end of that recording?
get out of my office.
Yeah. When Mr. Ireland said that you were getting effed, did you think that he meant that you were literally going to get effed?
Objection, Your Honor, relevance. This is beyond the scope. And those are the state's argument.
All right, beyond the scope of the motion to suppress or the motion to dismiss?
This would be for both. They're talking about what words mean or should mean or literal meaning, and it has no business in either the motion to suppress or the motion to dismiss.
All right, that objection will be sustained. You can ask your next question, counsel.
What do you expect when you walk into an attorney's office?
What do I expect when I walk in? Well, confidentiality, of course.
Do you expect that the attorney's going to be on your side?
Absolutely. Or you sign a contract with them. It's there.
And did you ever try to did you ever try to hire your wife's lawyer?
Objection, Your Honor, relevance.
Sustained.
Would your comfort with your would you when you talk about dead bodies, would you have that kind of conversation with Ms. Hesbrook or with the opposing lawyer?
Objection, Your Honor, relevance and outside the scope.
All right, that'll be sustained.
Did you have any means to execute any kind of threat?
No.
Did you have any kind of intent to threaten anybody in the courthouse?
No.
Did you have any intent to threaten Mr. Medley?
No.
Did you have any intent to threaten your ex-wife?
Objection, Your Honor. It is beyond the scope of both motions.
Our motion to dismiss talks about mens rea and the intent and the mind of the accused. And so I think if he's taking the risk of subjecting himself to a cross-examination from Mr. Duffy, well, then he can ask his questions as much as he wants
Well,
on
what-
redirect.
What I can tell both parties with regards to mens rea and whether or not he had the appropriate mens rea, that is really for a jury to decide and not for the court to decide whether or not he acted knowingly, intentionally, unless you all are coming to the court for a bench trial. Otherwise, that's
not what
really
this
within
is.
the purview of a jury.
Right, Judge. We're agreeing to move forward for this on a suppression. Mr. Allen is agreed to give his testimony regarding the suppression and the dismissal motion, but he's not giving his consent to be heard in front of a jury right now.
No, I'm just saying
That's
that
problem.
the mens rea part of it,
Mhm.
that would only come down to, jury trial or a bench trial, not for necessarily a motion to suppress or for me to determine in a motion to dismiss whether or not he exhibited the appropriate mens rea.
Okay,
That would be the state's argument, is it's outside the scope of this hearing and it should be a matter for the trier of fact.
All right,
fine.
so that objection will be sustained.
Mr. Allen, what's your understanding of free speech in the United States?
then you have the freedom to speech, exactly what it means.
And do you think that that your attorney's office is a location where you can execute that right?
Objection, Your Honor, relevance, but outside the scope as well.
All right, that'll be overruled. I'll allow him to answer that question.
Absolutely.
Why?
Because one, it's America. Number two, it's because when you talk with your lawyers, you're supposed to be in confidentiality.
Is it because you're making plans with your lawyer regarding the tactics that you're using in the litigation?
Absolutely, hence the confidentiality.
Would you want the other side to know? Would you want your wife's lawyer to know what you've talked about with your lawyer?
Objection, Your Honor, outside the scope.
Sustained.
Mr. Allen, why do you think that the court should suppress the audio recording made by your prior lawyer?
Objection, Your Honor, speculation, but also calls for a legal conclusion to which this witness is inappropriate.
Sustained.
In that recording, you were expressing some fear, frustration, and using some of this language. Was this, and this is a question, was this something that you had a plan? Did you think that you were committing a crime by going in and talking to your lawyer about these things?
Objection, Your Honor, relevance and speculation.
All right, that'll be overruled. You can answer that.
Did you think you were committing a crime when you went in?
Absolutely not.
I'm going to pass the witness.
All right, state.
Just a brief moment, Your Honor, sorry. Your Honor, the state has no questions.
All right, you may step down. Cindy, don't forget your microphone. Any other witnesses?
That's it, Judge.
State, any further witnesses?
No further witnesses from the state, Your Honor.
All right, then we'll close the hearing and we'll come back tomorrow morning and I'll hear arguments on both motions.
Shall we expect that to be at 9?
It depends on when he gets here. All right. All right, thank you, everyone.
Thank you, Judge.
The next day.
All right, if parties will come forward. Hello, Mr. Allen.
Hello.
Just give me one moment. All right, if everyone can please whisper, we're going to go on the record. Court is calling 2025 CR 007563, State versus Ronald Allen. Could I have parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Charles Butcher for the accused.
All right, and are you Mr. Allen?
Yes, I am.
We were here yesterday. The court heard evidence on defense's motions. The court ordered or requested that both parties be present today to make their arguments. And so defense, it is your motion. So, and both parties agreed for the hearing that they would combine the motion to suppress and the motion to dismiss. The court requested if both parties would agree to combine the motion to dismiss and the motion to suppress due to objections that both parties were having to particular evidence. And some of the objections with regards to the motion to suppress were not appropriate for a motion to suppress, but they were appropriate in the motion to dismiss. So that is why both parties agreed to combine the two motions. So with regards to the motion to suppress, what I would like to start with is we'll start with number 2, where the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. The reason we think that this lacks there's a lack of criminal conduct on this matter, because from the outset, the prosecution relied on a paraphrase quote allegedly said by Mr. Allen, which was, "If I don't get custody, I will make history and there will be dead bodies everywhere." But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was going to do that and I knew all this stuff was going to happen, period, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro." Later, he says, because if they don't get busted, there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim. There is no identified target. And there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact. I think that this misstep undermines the reliability of the charging process and bolsters the necessity for judicial correction through either suppression or the dismissal.
All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment, and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge. We do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day. And I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Exceptions, yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that?
Yes, Judge, we do know that there are rules, Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing that he had discretion under this section if he reasonably believed the disclosure was necessary to prevent a future crime. However, according to those rules, the comments inside of those rules, comment 13 to 14 in the rules that are promulgated by the state, the magnitude, proximity, and likelihood of harm must be weighed. The threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording, and that recording was not narrowly tailored as a warning. And then we have his own testimony where Mr. Ireland gets on the stand and he tells us, also in the recording, "I'm not afraid of anything regarding this case." That contradicts a reasonable belief of a grave and imminent harm.
But counsel, wasn't his saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and I do know that what we're really talking about is that Mr. The lawyer that testified, that was this man's lawyer. He continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. The first thing is that the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney about legal matters that they've been contracted to do, that normally it's privileged. But I think both parties have also stipulated that there are exceptions to that privilege. And one of them is if there is a threat of future criminal activity, or if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense? whether or not that was privileged.
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies, implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the disciplinary code 1.05C7. The court is finding that the recording is not illegal as Texas is a one-party consent state, and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge, that goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F'd. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way, but what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, I'm scared for my life, dude. That That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are in the constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, "If they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ." This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats toward the president. But the Supreme Court found in 1966 that they reversed the conviction, holding that Watt's statement was political rhetoric and not a true threat, and therefore was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in. Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case, where a defendant told officers, "Y'all better wear your vest because I'm going to start shooting." This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the Criminal Code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alanis v. United States case, where the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, "I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen." He further elaborates, "Hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls. When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat
But
to the general public.
at this juncture, isn't whatever your client's intent, that's something for a jury to decide? Or if this were a bench trial, then it would be for me to decide. But is that correct? That that's something for the jury to decide whether what his intentions were. At this point, my only, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the exception to that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with point number 5 in the motion to suppress, that the statement was not a true threat. The state is offering to the court and to defense what is Garcia versus State, 583 Southwest 3D 170.
Thank you.
All right, and I'm aware of the case, but I'll review it. So thank you.
Judge. I have flagged a couple important spots. The First Amendment does not protect speech like this. A true threat, and Your Honor, you will find this, I believe, on page 2, that first flagged one. True threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. In this case before the court, we heard the recording on Wednesday, 3 times, Wednesday, Wednesday, Wednesday. When the defendant talks about dead bodies everywhere happening on Wednesday, I'm gonna make history. This is not hypothetical. This is distinguishable from Watts. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It does not matter if he intended to carry it out. The intent is to place the public in fear. It was directed to a specific date. We entered that Wednesday court date in the civil courthouse. It was, it was not a joke. It was not to be taken lightly. On that same case before the court, if we may go to page 3, defense spoke of lack of mens rea. Paranoia is not a criminal element. This conversation was more than exploring conspiracies against the defendant. This was not a private emotional procession or communication with the attorney. This is more than delusional, exaggerated, and distressed. It was a terroristic threat. He was not seeking knowledge. He wanted a reaction. Was it to light a fire? Who knows? But the fear was more than just at the office. It is at the courtroom. It involved the families involved in the civil proceeding. This type of language is not protected under the First Amendment. It is a true threat, and therefore, defense's point number 5 should be denied.
Why?
Ronald Allen
Objection,
sat at the
Your
center of a
Honor.
courtroom storm,
This is-
accused not of violence itself, but of words that echoed like
It is
gunshots.
beyond the scope.
What began as a
the-
private meeting with his
of both
attorney over a
motions.
bitter custody battle
Our motion to
spiraled into
dismiss
criminal
talks
charges
about
that
mens
threatened to
rea and the
redefine free
intent and the
speech,
mind of the
privilege, and
accused.
fear.
And so I think if
Prosecutors
he's taking the
painted
risk
Allen as a man
of
who
subjecting
crossed a
himself to
line, arguing that his
cross-examination
talk of dead bodies
from
everywhere
Mr.
tied
Duffy,
to a specific
well, then
Wednesday
he
was
can
a
ask
true
his
threat
questions
aimed at
as much as he
shaking the
wants
courthouse.
on
Well,
redirect.
What I can
They
tell both
emphasized
parties with
warrants,
regards to
recordings,
mens rea
and the ripple
and
effect
whether or
of
not
fear that
he
followed,
had the
insisting
appropriate
public
mens
safety
rea,
outweighed
that is
confidentiality.
really for a jury to
The defense
decide and
countered
not
with
for
a
the
different
court to
portrait.
decide whether or not
Allen, they said,
he
was a distraught
acted
father drowning
knowingly,
in frustration,
intentionally, unless you
betrayal,
all are
and
coming to the
paranoia
court
after
for a
years of
bench
family
trial.
court losses.
Otherwise,
That's
He
not
believed he
within
was
the
speaking
purview of a
confidentially,
jury.
venting to the one
Right,
place
Judge.
he thought was safe.
We're agreeing to move
There were no
forward for this on a
weapons, no
suppression.
targets,
Mr.
no
Allen
plan,
is
only
agreed
chaotic
to
language
give
born
his
from emotional
testimony regarding
collapse.
the suppression
They
and the
invoked
dismissal
constitutional
motion,
precedent,
but
arguing
he's not giving
context
his
mattered
consent
more
to be
than
heard
sound
in front of a
bites,
jury
and that
right
reckless
now.
words were not the
No, no,
same
no,
as
I'm just
criminal
saying
intent.
that the
The
mens rea
judge
part
became the
of it,
fulcrum.
Mhm.
that would only come
Methodically,
down
she
to,
separated what the court could
you
decide
know,
from what
jury
only a
trial
jury
or a
could
bench
weigh.
trial, not
She
for
ruled the recording
necessarily a
legal,
motion
the
to
privilege broken by an
suppress,
exception
or
for
for me to
threats, and
determine
the
in
arrest
a
valid under warrant.
motion to dismiss
Intent, she
whether or
said, was
not
not hers to
he
judge today. With that,
exhibited the
both
appropriate
motions
mens
fell.
rea.
The case
Okay.
would move
That would be the
forward,
state's
not
argument, is
resolved
it's
but
outside
sharpened,
the scope of
leaving
this
Allen
hearing, and it
facing a
should be a
jury
matter
and the
for the
state
trier of
standing
fact.
firm.
All
The
right.
room emptied,
Fine.
yet
So-
the
so
tension
that
lingered,
objection will be
asking an
sustained.
unsettling question. When fear, frustration, and speech collide, who decides
Mr.
the
Allen,
moment
what's your
words become a
understanding
crime?
of
The
free
answer
speech
may
in the
define
United
justice
States?
itself, long after the gavel falls, and
yeah.
long after this courtroom
have the
decides
freedom
whether
to
fear or
speech.
intent truly rules
Exactly
in
what it
modern law
means.
and public
And do you
conscience.
think that